Hey everybody, this is Chris Haddock with the Veterans Law Blog, coming to you live on Facebook here on Friday, November 2nd, 2018. So it's been a while since I've jumped on a Facebook Live video with y'all. Figured I'd jump on this morning. I miss doing these videos, miss the chats, so the idea is I'm just going to sit on here and talk about some stuff going on in the world of BVA claims, BVA appeals and VA claims, and then hopefully if I have a little bit of time after talking, if I don't go on too long, let me start my timer so I don't go on too long, I'll jump on the comments there a little bit and see if I can chat with some of your comments and answer some of your questions. So I do have to jump off here in about 20 minutes. I've got a conference call with the court on a client's case, so I'm going to jump off, but I should be able to. Hey Wade, how you doing? Nice to see you. Thanks for joining us. Listen, it's been a while since I've done one of these videos, as I mentioned, and there's good reason for that. So I've been doing the Veterans Law Blog for, actually today is the 11th year. Started in 2007, and now here 11 years later, we've got one of the largest followings of veterans that are learning to improve their own VA claims and appeals without the need for VSOs or attorneys. Or if they do need a VSO or attorney, they get it after a really well-developed claim. So we've accomplished some great things, helped a lot of veterans, got a lot of information. I mean, there's literally thousands of posts on the blog. There's a handful of books, training videos that we've got more coming in the coming months and year. So the reason I haven't been on a lot on video, though, is because of a big change that happened at the end of 2017. Congress finally passed a law. I know it's kind of a shock for all of us to hear this, as Congress finally did something. They passed a law and the President signed it in. It was called the Appeals Modernization Act. So this is actually something that started way back under Obama. The last 2 years of the Obama administration, folks were working to get this act pushed through. And the idea was to streamline the BVA appeals process. I'm not sure how successful they'll be, but the bottom line is we have this crazy, insane process by which they're going to change over from the old system to the new system. And because of that, I haven't been getting on a lot to talk to you about the new system because we don't know the rules for the new system yet. Nobody's really navigated the new system because it hasn't yet gone into effect, so I can't tell you anything more than what's written in the statutes about this system. I can't tell you the sort of things that I can tell you about the old legacy claims process or legacy appeals process, where I can tell you some of the pitfalls or the traps. I can teach you some of the shortcuts or some of the ways to make your claims or appeals better, because I've worked those claims. I handled them for years and years and years. And I talk to attorneys that handle them. Right now, nobody has any clue how this new system is really going to work. I mean, we can all read the statute. We can all read the PowerPoints that the BVA is putting out. We can all read, the stuff that's coming out in the VA videos and all that nonsense, but nobody really knows. And I'll give you an example. Earlier this month, I was up in Washington, D.C., and I sat in on oral arguments at an appeal before the U.S. Court of Appeals for the Federal Circuit, and the case is called Cook. And it goes back and it's looking at a statute that was originally passed in 1958 that gave veterans a right to a hearing at the BVA. And the question is, do you only get one hearing, or do you get a hearing anytime it comes back to the board in a particular appeal? And I won't get into all that sort of stuff, but the point that I'm trying to make is that we had a statute in effect for 50 years, and nobody really figured out what it meant. So certainly here, less than a year, well, I guess now it's been a year and 3 months since that new law was passed, and it's really about 3 to 4 months before it goes into effect. Nobody can tell you what's going on with that law. So what you'll see on the blog are posts describing the process as we know it. I was involved in helping some organizations advocate for some language in this statute. Not everything that we wanted made it in. Some of the stuff that we didn't want made it in, and we got some really good stuff in there too. But the bottom line is nobody knows how this process is going to work. And so we're going to have to play it by ear. We're going to have to work through this together over time. And that's what's cool about this, is there has never been a point in the VA claims or appeals process where there's been a major change in the statutes or the regulations that govern that process, where you've been able to work through it with somebody on social media, on video, live. We can sit and we can work through some of these things and figure it out together. I also have to figure out what to do with thousands of blog posts that are out there about what's being called the legacy system. and how to make sure that when you, the veteran, hop on the blog, you know whether the post you're reading, the video you're watching, the book you're reading applies to the legacy process, the old process that will continue to be in effect for probably at least 8 to 10 years, or whether you're seeing something for the new quote-unquote modernized process. And oh, by the way, it gets a little bit more complicated because the VA decided they just did not have enough acronyms, and so they created a process to phase folks in from the legacy to the modernized, and also to test out and make sure they knew what they were doing in the modernized process, which, you know, hey, do that before you pass the law, right? Anyway, so this process is called RAMP. And RAMP is kind of the segue, or the go-between between the legacy process and the new process. So most of you are getting the letters. The VA is pushing this RAMP system pretty hard. I'm staying away from it like I stay away from poison oak, just because I know what it'll do, which is absolutely nothing. You get in this process and all it is it's a tool to switch you into the legacy system where you sit and wait. And there's no guarantee that you're going to be first in line under the new modernized process. The regs don't cover that. So it's a little bit confusing, and we've decided that with our clients, we're just going to recommend that they wait until the appeals modernization comes out. The regs were published just about, I think it was about 3 or 4 weeks ago, they published the regs. Now, the process for doing that, they have to provide notice to the public before they go into effect, give the public an opportunity to comment on those regulations, then they will revise them and release them. Even after those regulations for the new modernized appeal process are published and have gone through the notice and comment, then 2 things are going to happen. First, the VA has to certify to Congress that it's ready for this new system, and Congress has to believe them. So I'm not sure that second piece is going to be an issue, because I think kind of right now we've got, at least, you know, the last decade or so, we've just got a rubber stamp Congress, but if they stamp anything at all. But the real question is the VA going to certify that they're ready in February or March of 2019? And then the second thing that we're going to have, I can almost guarantee it, is there are going to be what are called regulatory challenges under the Administrative Procedures Act. And I know that there are several already being drafted up, ready to go, because we've looked at these regs and they don't properly interpret the statutes, and they don't properly interpret congressional intent, and they read in ambiguities that aren't in the statute. And they take away rights from veterans that the statute either created or did not itself remove. And so we know that these suits are going to come pretty fast and furious after the regs are published, and they're going to be filed in the U.S. Court of Appeals for the Federal Circuit, is where you bring your Administrative Procedure Act challenges to newly published federal regulations. In any event, that's a whole bunch of legalese nonsense out there. The bottom line is we got a new process coming. The old process is going to be there for 8 to 10 years, if not more, right? I mean, we've still got millions of appeals in that old pipeline. There's a third process that's a go-between between number 1 and number 2. And then we've got confusion as to when the regs go into effect, confusion about what regs will be in effect. Hey, Terry, how you doing? Nice to see you. Thanks for dropping in. We've got all sorts of confusion, and on top of that, nobody out there can tell you how this system is going to go. Anything that you read about RAMP or appeals modernization, you should read or listen to or watch, and it includes what I say too, with a raised eyebrow, with suspicion, because nobody has enough experience in this process to be able to identify patterns, loopholes, traps, accelerators, any sort of thing that you can do in the process to make things go quicker. Nobody knows. So we're going to have to work through this together. Stick with the Veterans Law Blog. I can guarantee that we will be talking about it in the weeks and months ahead. Until then, until we get more information, I'm going to continue talking to you about the things that I like talking to you about. Hey Jermaine, how you doing? Nice to see you. The things that I'm going to talk to you about are what medical conditions can be service connected, how to use evidence, lay or medical, to prove service connection, how to understand what the difference is between TDIU on a scheduler or extra scheduler basis. All these, the basic core substantive law of VA claims is not changing. The VA claims process is not changing. What's changing is the appeals process between the time that you get a ratings decision and you get a board hearing, a BVA decision. That's what's changing. So all that claim stuff isn't changing. The court stuff isn't changing. Hey Mike, how you doing? You're welcome. Hopefully this information's helpful. The only thing that's changing is that appeal. So we're going to keep talking about these parts, and we're going to keep talking about the substance of your appeals and claims, evidence, legal concepts, because I believe that if veterans have some basic understanding about how law works and how legal systems should work, how evidence works, all those sorts of things, how to better argue, how to better write, how to better present your arguments, then you will have a better experience in whatever process is out there. So I will jump on after this and answer some of these questions in the comments as I have some time. We've got about 10 minutes of live video left. I want to talk to you about a couple of things, but it's good to see you, Tony. That's a good question. And the short answer is, watch the first 10 minutes because nobody knows at this point, right? But we'll talk. I'll get you some more information in a response there in the comments after the video. In any event, the one thing I do want to talk to you about is sleep apnea. So I've spent a good bit of my time as a veterans advocate handling sleep apnea claims, teaching advocates how to win and attorneys how to win sleep apnea claims for their clients, teaching you guys and you folks out there how to prove and hopefully win a sleep apnea claim. I've got a book we've written, it goes back, it's going to be backwards up on your screen because we're doing this forward-facing video, but the Sleep Apnea Field Manual, I'll pop the link up in the notes or the comments so you can pick up a copy yourself, walking you through everything you need to know about proving up a sleep apnea claim with the VA. That'll change a little bit with the new process, but that said, one thing that I see a lot, I see this a lot, and I want to talk to you about it, is I see veterans filing sleep apnea claims, and what they're arguing to the VA or to the BVA or at the Veterans Court, they're arguing that, hey, listen, I snored a lot in service. I was snoring all the time. I got my battle buddy there that used to, kick me out of bed because I was snoring so much, or kick me out of the bunk, or kick me, make me sleep on the hood of the Humvee because I was snoring so much, and get all this lay evidence talking about how much you snored. And here's the deal, folks. Snoring really doesn't matter a whole lot for sleep apnea. It really doesn't. Now, you're going to have a certain type of snoring, and that's what I want to talk to you about. I want to talk to you about the symptoms of sleep apnea so that you can start looking through those service medical records. You can start building the lay evidence that actually helps you document the symptoms of sleep apnea that may have existed undiagnosed in service. Snoring ain't going to cut it. Snoring by itself, I have seen more appeals denied, more claims denied, and there's nothing as a court attorney, as an appellate attorney, there's very little I can do if you're hanging your hat on evidence of snoring as proof that you had sleep apnea in service. So what symptoms are there for sleep apnea? Well, any of the three types, and remember there's three kinds of sleep apnea. There's obstructive sleep apnea, which is where your airway, something between where the air comes in your nose and where the oxygen gets into your lungs, something in that pathway is obstructing the passage of air, right? That's obstructive OSA sleep apnea. There's a second kind called central sleep apnea, and that's where something up in the brain is not telling the body to breathe properly, and it's a nerve issue, some sort of nerve transmission, a break in the nerves, and it's some sort of neurological issue between the brain and the muscles and the components of the body that actually start and execute the breathing process that's not working properly, and as a result you're not getting oxygen in. That's called central CSA sleep apnea. And then there's complex, which is complex. It's pretty much something that presents as obstructive or presents as central, and then with treatment shifts to the other or appears more of the other. And then there's a fourth kind out there that's really very new and really isn't an official diagnosis. I'm not going to talk about it. But in any of those types of sleep apnea, the number one symptom is this certain type of snoring, and it's actually not really snoring, it's stopping breathing. And so if you know somebody that has sleep apnea, I encourage you, just if you want to see what it looks like from an outside perspective, watch somebody with sleep apnea and that does not have a CPAP or some sort of breathing assistive device try to breathe. What you'll see is they'll stop breathing, and then all of a sudden, after what seems like an interminably long period of time, they'll just start gasping for air. And I'm not going to make the sounds here, but you get the idea. And a lot of times in the process of doing that, the person will wake up. Well, that's called an apnea event, and that's where something has stopped the body from breathing. You have stopped breathing while you're sleeping. That's what sleep apnea is. You stop breathing while you're sleeping. So snoring, snoring could be anything. Snoring could be, you could have a cold and snore. You could have heavy smokers snore a lot because they've got some, buildup on their air pipes and lungs. Air pipes is actually medical terminology, right? Official medical terminology, but it's not. I'm just being silly. But there's a lot of reasons you could snore. Snoring could simply be the sleep position that you're sleeping in. And so if you're hanging your hat on evidence of snoring alone in service as evidence that you had sleep apnea, you're probably going to lose your claim. What you need is you need to really dial into that sleep breathing issue, that you stop breathing, and that lay evidence needs to show that there's somebody that observed you. Maybe it's your wife, maybe it's your significant other, maybe it's your battle buddy, maybe it's somebody that shared a bunk with you on a submarine or whatever the case may be, that was aware when you were sleeping that you would stop breathing. That's the sort of evidence you need. There's other evidence too. So there's other symptoms of sleep apnea, and some of the more common ones. You wake up in the morning and you feel dehydrated in your mouth, and you've got throbbing headaches, and those headaches are usually in the same place. You've got you're falling asleep during the day. You wake up in the middle of the night for no good reason, right? You just wake up and you don't remember why. I will tell you that some people have sleep apnea so bad that they wake up and they actually experience and feel the actual apnea event. The BVA will tell you that's not possible, that you can't observe yourself stopping breathing while you're sleeping, and I call horse shit on that. But in any event, that finding is getting rarer and rarer as we get word out there. But in any event, the key thing I want to talk about, and you can learn more, pick up the book. It's available as an ebook on the Veterans Law blog. Sometime here in the next 3 to 4 months, we're going to be releasing a training video on sleep apnea. You can learn how to actually prove up your claim. This isn't the point that I'm trying to make here, is how to prove a claim. What I'm trying to suggest is that we really need, as veterans with sleep apnea claims, we need to step back and make sure that our only argument for sleep apnea in service is something more than just snoring, because snoring alone does not cut it. So I want to get that word out. I've seen a huge increase, a huge spike in the number of BVA decisions that I'm seeing, and claims that I'm reviewing, denied claims, where that's all the veteran says is, I snored, I've got sleep apnea, they're related. And that's not true. That's not enough. It's not going to get you there. In any event, if you're denied a sleep apnea claim, there's a lot of attorneys out there doing it now, but I think in most cases, if you've got the ability to get the sleep study and hire the experts, you can do it on your own, get the book. If you can't or you don't want to, absolutely hire an attorney. I recommend an attorney for appeals. If you need to hire somebody, there are some really good VSOs out there, but they're really strongest in the claims process, not the appeals. That's just my personal opinion, and I don't mean to malign or attack any VSOs. I certainly don't. They do the Lord's work out there. God bless them. Love everything you do. You guys are doing great work. Not everybody, just like all attorneys. Not all attorneys are great, but I really do think VSOs, their strong suit is in the claims process. So listen, the last thing I want to talk about, and I've got about 2 minutes before I've got to jump off, and I got a call here with the court coming up. So I'm going to jump off and hopefully get a little time in the comments with you. If I don't, I'll come back after my call with the court and hop in the comments. So in any event, what I want to talk to you about is the BVA. This last thing, the third thing, is the BVA, the Board of Veterans' Appeals. Right now, they are cranking out decisions, often like 4 to 5, maybe even 8 to 10 times as many decisions this year as they have in any other year in the past. And here's what's going on. I talked to you in the first part of this show about this new appeals modernization program. To make the new system work, they have to clear out the legacy system, and there are hundreds of thousands of appeals in that legacy pipeline, and so they are just spitting them out left and right, spitting out decisions, going through them really quick. I think it's something like I want to say it's like 80,000 decisions at this point in the year already, maybe already higher, because that might be an old number, and they usually do about 25,000 a year, 20,000 a year, so that's a lot. The court's flooded with appeals as well, and that's because the quality of these decisions coming out, folks, is bad. These decisions are really low quality. Now, I know I'm not maligning any judges, but I want to tell you that haste makes waste. It's a saying that I heard as a kid, and it's a saying that echoes in my head every time I see the BVA bragging about how much they're kicking out in terms of appeals. They tried to hire more judges. They got Cheryl Mason as the new chairman of the BVA, the first chairman that we've had in decades, and she's doing a great job. I think she's doing a great job trying to get things changed. She actually got a bunch of judges to help lighten the load and increase the quality. And because of all the bullshit political games that are going on, only the Republican judges were approved and the Democrat judges were shot down. So I don't know what the hell's up with the nonsense, but it's hurting us. We only got half of the new judges, so these decisions are going to continue to get cranked out. They're overworked, so they're going to be low quality. And the point isn't to get into politics. I don't care about any of that stuff. I really just want it to stop so that we can get focused on the work that we need to do. And the work that we need to do right now is, if you get a BVA decision, if you get a decision from the BVA denying your appeal, you need to have an attorney. That's my alarm to start jumping off here. You need to have an attorney take a look at that. I can almost guarantee that if you're looking at a BVA decision denying you an increase on a knee or a back rating, denying you an increase on PTSD or a mental health rating, denying you TDIU, denying you an extra scheduler rating, denying you service connection for PTSD, those claims right there, if you are seeing decisions denying them, I can almost guarantee there's an error in them. And reach out to an attorney that does court work. Our firm does it. I'm not here to pitch my firm. You can get on the NOVA website, vetadvocates.org, and there's attorneys there that do it. You can jump on my website, addictsteel.com, and check us out. We do almost exclusively court work at this point. But again, I'm not pitching my firm. I want you to get out there and look at attorneys at the court if you get denied by the BVA, because there's a very high degree of likelihood that there's a legal error in there with the rapidity, is that even a word, with the speed and the low quality with which they are cranking out these decisions. I've got another book. This is a free ebook online, or you can pay a couple bucks and get a hard copy. Is How to Choose a VA Claims Attorney. And it's a good 60 pages of information full of questions you can ask an attorney, how to tell when an attorney knows what they're talking about, or when they're full of it. You can check this out. This book has helped a lot of people make really good decisions about hiring attorneys, and I encourage you to take a look. It's a free ebook online on the veteranslawblog.org, so just go there, click on the store, and pick up the free ebook, or pick up a copy for a couple of bucks if you prefer paper. So, in any event, guys, it was good to get back here and chat with everybody. I'm going to jump on the comments for a few minutes, and then I got to get going to this court call. But it's good seeing y'all. Keep your eye out. We're trying to do more frequent posts, and we're certainly going to try to do a lot more of these videos as we go forward, and we've got some other things coming. So stay tuned. Looking forward to chatting with you, and have a great weekend.